This presentation will focus on an overview of 35 U.S.C. Section 112, specifically the analysis that is required for 112B and 112D. We will also discuss how 112B and 112D are applied during patent examination. A patent grants, for a limited period of time, an applicant or their designee the right to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or importing the invention into the U.S., in exchange for the public disclosure of the invention. Therefore, Congress requires a patent applicant to provide a distinct and specific statement of what applicant claims to be new and to be their invention. The text of 35 U.S.C. Section 112, as amended, is provided on this and the next two slides. This statute has 6 paragraphs, formerly known as paragraphs 1 through 6, but now designated as A through F. 112A will be covered in a separate presentation. This presentation will focus on 112B, which requires that the specification shall conclude with one or more claims, particularly pointing out and distinctly claiming the subject matter which the inventor or a joint inventor regards as the invention. The primary inquiry when examining claim language under 112B is whether the language leaves room for ambiguity or whether the boundaries are clear and precise. This presentation will also focus on 112D, which requires that a claim-independent form shall contain a reference to a claim previously set forth and then specify a further limitation of the subject matter claimed, and goes to state that a claim-independent form shall be construed to incorporate by reference all the limitations of the claim to which it refers. 112F will be covered in a separate presentation. 35 U.S.C. Section 112B is a statutory requirement for the inventor or joint inventor to define precisely what the invention is. Thus, 112B focuses on the claims. It is the claims of the patent which define the invention for which the patentee is entitled the right to exclude others from making, using, and selling the invention. In reviewing a claim for compliance with 112B, you must consider whether it provides clear warning to others as to what constitutes infringement of the patent. If it does, then it is said to serve the notice function required by 112B. The purpose of the claims is not to explain the technology, how it works, or how it can be used, but to define the legal boundaries of the patent. The primary purpose of 112B is to ensure that the scope of the claims is clear so that the public is informed of the boundaries of what constitutes infringement. This means that the claim language must be definite to comply with 112B. Conversely, a claim that does not comply with this requirement of 112B is indefinite. Definiteness of claim language also helps you determine whether the claimed invention meets all the criteria for patentability, and whether the specification complies with 112A by providing a clear measure of what applicants regard as the invention. There are 2 separate requirements in 112B. The first requirement is that the claims must set forth the subject matter that applicants regard as their invention. This is a subjective requirement, and rejections under 112B are rarely made on this basis. A rejection based on the failure to satisfy this requirement is appropriate only where applicant has stated, somewhere other than in the application as filed, that the invention is something different from what is defined by the claims. In other words, the invention set forth in the claims must be presumed, in the absence of evidence to the contrary, to be that which applicants regard as their invention. The second requirement is that the claims must particularly point out and distinctly define the metes and bounds of the subject matter that will be protected by the patent grant. This is the definiteness requirement. The definiteness requirement is an objective requirement because it is not dependent on the views of applicant or any particular individual, but it is evaluated in the context of whether the claim is definite. The claim is definite if the scope of the claim is clear to a hypothetical person possessing the ordinary level of skill in the pertinent art. Definiteness of claim language must be analyzed, not in a vacuum, but in light of the disclosure, the teachings of the prior art, and the claim interpretation that would be given by one of ordinary skill in the art. The inquiry during examination is patentability of the invention as applicant regards it. If the claims do not particularly point out and distinctly claim that which applicants regard as their invention, then the appropriate action is to reject the claims under 112B. However, if the claims, when read in light of the specification, reasonably inform those skilled in the art of the use and scope of the invention, and if the language is as clear and precise as the subject matter permits, then the claim satisfies the requirements of 112B. Similarly, if the scope of the subject matter embraced by the claims is clear, and if applicants have not otherwise indicated that they intend the invention to be of scope different from that defined in the claims, then the claims comply with 112B. Breadth of a claim is not the same as indefiniteness. Undue breadth of the claim may be addressed under different statutory provisions, depending on the reasons for concluding that the claim is too broad. If the claim is too broad because it does not set forth that which applicants regard as their invention, as evidenced by statements outside of the application as filed, a rejection under 112B would be appropriate. If the claim is too broad because it is not supported by the original description or by an enabling disclosure, a rejection under 112A would be appropriate. If the claim is too broad because it reads on the prior art, a rejection under either 35 U.S.C. 102 or 103 would be appropriate. During the examination of a patent application, the claims must be given the broadest reasonable interpretation consistent with the specification. Additionally, the broadest reasonable interpretation must also be consistent with the interpretation that those skilled in the art would reach. Prior art references may be indicative of what those skilled in the art generally believe a claim term means. An example comes from In Re Courtright. There, the board's construction of the claim limitation, restore hair growth, as requiring the hair to be returned to its original state, was held to be an incorrect interpretation of the limitation. The court held that, consistent with applicant's disclosure and the disclosure of 3 patents from analogous arts using the same phrase to require only some increase in hair growth, one of ordinary skill would construe restore hair growth to mean that the claimed method increases the amount of hair grown on the scalp, but does not necessarily produce a full head of hair. Giving claims the broadest reasonable interpretation during examination serves the public interest by reducing the possibility that claims of issued patents will be given broader scope than is justified. Applicants' interests are not impaired, since they have the opportunity to amend claims during prosecution to adjust claim scope as needed. The first step in examining a claim to determine if the language is definite is to fully understand the subject matter of the invention disclosed in the application, and to ascertain the boundaries of the subject matter encompassed by the claim. If one of ordinary skill in the art cannot ascertain the metes and bounds of the claim so as to understand how to avoid infringement, you must reject the claim under 112B for failing to particularly point out and distinctly claim the subject matter which the inventor or joint inventor regards as the invention. If the language of the claim satisfies the statutory requirements of 112B, a rejection is not appropriate. A rejection under 112B should not be used to merely require applicant to improve the clarity or precision of language in a claim that already satisfies the statute. The specification ideally serves as a glossary to the claim terms, so that you and the public can clearly ascertain the meaning of a claim term. Claim terms must find clear support or antecedent basis in the specification. However, the exact claim terms are not required to be used in the specification. To meet the definiteness requirement under 112b, the specification should provide the needed guidance on the meaning of the terms. For example, by using clearly equivalent terms, so that the meaning of the terms is readily discernible to a person of ordinary skill in the art. Even though claims are read in light of the specification, limitations from the specification should not be read into the claims, because doing so impermissibly narrows the scope of the claims. Examiners play a critical role in developing the written record that is part of the prosecution history of an issued patent. Moreover, examiners have a duty to enforce 112b by requiring that claim language clearly defines the boundaries of the claim's scope. When claim language has unclear boundaries, a rejection explaining why the claim is indefinite under 112b is appropriate. Such a rejection shifts the burden of clarifying the boundaries of claimed protection to the applicant, who is best suited to explain what has been invented. In fact, courts and the Patent Trial and Appeal Board, or PTAB, will look and sometimes quote or cite to examiners' remarks when construing a claim and determining validity of a patent. As an example, recently, the Federal Circuit stated, "We have recognized the importance of the role that the USPTO can play in ensuring that patent claims are clear and unambiguous," noting in its written decision that the board reviewed and agreed with the examiner's identification of the indefiniteness problems that constituted applicants' failure to adequately comply with the statutory requirements of Section 112b, and for which there had been no satisfactory response from applicant. In re. Packard, 110 U.S. PQ 2D, 1785, 1789. Federal Circuit, 2014. Applicants have an equally important role in clarifying the record. They are in the best position to explain what patent protection is being sought and what they consider as their invention. Applicants have a duty to comply with 112b by ensuring that claim language clearly defines the boundaries of the claim scope sought. If claim language does not clearly define the boundaries of the claim scope, applicant has the opportunity and duty to clarify the claim boundaries during prosecution. Resolution prior to issuance helps prevent disputes as to claim meaning when the patent is enforced or reviewed, for example, in litigation or post-grant proceedings. When the examiner determines that the boundaries of a claim are not reasonably clear, a rejection under 112b should be made. In making a rejection, the examiner must identify the specific claim language that is indefinite and explain why that language renders the boundaries of the claim unclear. As required by 35 U.S.C. Section 132, enough information must be provided to enable applicant to make a meaningful response. Additionally, an explanation regarding claim construction should be provided when needed to assist in clarifying the examiner's position or to provide a context for the broadest reasonable interpretation that the examiner has given the claim. Further, whenever practicable, the examiner should indicate how the issues may be resolved, for example, by suggesting amendments to the claims that resolve the issues. By this, a rejection can better withstand later challenges at the PTAB or in court. A good example of this is in re. Packard, in which the Federal Circuit upheld an examiner's indefiniteness rejection, noting that when the USPTO has initially issued a well-grounded rejection that identifies ways in which language in a claim is ambiguous, vague, incoherent, opaque, or otherwise unclear in describing and defining the claimed invention, and therefore the applicant fails to provide a satisfactory response, the USPTO can properly reject the claim as failing to meet the statutory requirements of Section 112b. Packard, 110, U.S. PQ 2D, at 1787. Examiners should keep in mind that under the principles of compact prosecution, each claim should be examined for compliance with every statutory requirement for patentability in the initial review of the application. Thus, when the examiner determines that a claim term or phrase renders the claim indefinite, the examiner should make a rejection based on indefiniteness under 112b, as well as any other applicable rejection. When making a rejection over prior art in these circumstances, it is important that the examiner state on the record how the claim term or phrase is being interpreted with respect to the prior art applied in the rejection. Applicant can successfully reply in several ways to resolve an indefiniteness rejection. Applicant can explain why the language is definite and/or amend the claim to resolve the indefiniteness. Applicant and the examiner may also hold an interview, which may assist in resolving issues of clarity and interpretation of claim scope. Applicant's reply, along with the examiner's written explanation or interview summary, will provide a clear record of how the claim boundaries were defined prior to issuance. The examiner must consider applicant's reply to determine whether the issues of indefiniteness have been resolved. If the boundaries of the claim are still not reasonably clear, the rejection should be maintained, and an explanation as to what issues remain provided to applicant. When applicant's reply resolves the issue, it is a best practice to indicate on the record that the issue has been resolved and how it was resolved, if the record is not already clear. For example, if the applicant argues that a certain term is definite and also amends the claim, indicate which action resolved the issue. If the next section is a notice of allowance, reasons for allowance can include such an indication. If the issue was resolved during an interview, indicate such on an interview summary record. Providing such an indication enhances the clarity of the prosecution record by providing a written history of the boundaries of the claim as understood by applicant and the examiner during prosecution. Clarity of the prosecution record is of utmost importance because the record explains what deficiencies the examiner addressed and how the applicant overcame them during prosecution. The prosecution record will provide a map for the public to understand the boundaries of the patent protection and provide clear notice of patent rights. The PTAB in courts will be informed as to what the examiner and the applicant understood the claims to mean. In the context of 112B, a clear record improves the clarity of claim limitations in a granted patent by reflecting the mutual understanding of the scope and content of the claim reached by the examiner and the applicant. MPEP 2173.05 provides guidance on specific topics where issues under 112B have been addressed. Note that this is not an exclusive list of all issues that can arise under 112B. Only some of these topics are addressed in this presentation. Additional topics are discussed in other presentations. You should refer to the MPEP for more detailed information. When new terminology is used in a claim, the meaning of the term should be apparent from the prior art or from the specification and drawings at the time the application is filed. Applicant is entitled to be his own lexicographer and may use terms in a manner contrary to or inconsistent with one or more of their ordinary meanings, as long as the written description clearly redefines the terms. Definiteness problems often arise when words of degree are used in a claim. The fact that claim language may not be precise, however, does not automatically render the claim indefinite under 112B. Acceptability of the claim language depends on whether one of ordinary skill in the art would understand what is claimed in light of the specification. When a term of degree is used in the claim, you should determine whether the specification provides some standard for measuring that degree. If the specification does not provide some standard for measuring that degree, a determination must be made as to whether one of ordinary skill in the art could nevertheless ascertain the scope of the claim. For example, does the specification include a standard that is recognized in the art for measuring the meaning of the term of degree? Likewise, the claim is not indefinite if the specification provides examples or teachings that can be used to measure the degree even without a precise numerical measurement. Lack of antecedent basis can also render a claim indefinite. An example would be if a claim refers to a said lever or the lever, but the claim contains no earlier recitation or limitation of a lever, and it is unclear as to what element the limitation was making reference. Similarly, if two different levers are recited earlier in the claim, the recitation of said lever in the same or subsequent claim would be unclear where it is uncertain which of the two levers was intended. A claim which refers to said aluminum lever but recites only a lever earlier in the claim is indefinite because it is uncertain as to which lever reference is made. Inherent components of elements recited have antecedent basis in the recitation of the components themselves. For example, the outer surface of said sphere would not require an antecedent recitation that the sphere has an outer surface. The mere fact that the body of a claim recites additional elements which do not appear in the claim's preamble does not always render the claim indefinite under 112b. You should consider the totality of all the limitations of the claim and their interaction with each other to determine whether the claim apprises one of ordinary skill in the art of its scope. If the scope of the claim is reasonably ascertainable despite a lack of explicit antecedent support, then an indefiniteness rejection is generally not appropriate. Antecedent problems in the claims are typically drafting oversights that are easily corrected once they are brought to the attention of applicant. Your task of making sure the claim language complies with the requirements of the statute should be carried out in a positive and constructive way, so that minor problems can be identified and easily corrected, and so that the major effort is expended on more substantive issues. Description of examples or preferences is properly set forth in the specification rather than the claims. If stated in the claims, examples and preferences may lead to confusion over the intended scope of a claim. You should analyze whether the metes and bounds of the claim are clearly set forth. Materials such as rock wool or asbestos, for example, was held to be indefinite because it was unclear whether applicant is claiming rock wool or asbestos, or all materials similar to rock wool and asbestos. Alternative expressions are permitted if they present no uncertainty or ambiguity with respect to the question of scope or clarity of the claims. A Marcouche claim is a type of claim that recites a list of alternatively usable species. A Marcouche claim is commonly formatted as selected from the group consisting of A, B, and C. However, the phrase Marcouche claim means any claim that recites a list of alternatively usable species regardless of format. Note that it would be improper to substitute comprising rather than consisting of. A Marcouche claim may encompass a large number of alternative species, but it is not necessarily indefinite for such breadth. In certain circumstances, however, a Marcouche group may be so expansive that one skilled in the art cannot determine the metes and bounds of the claimed invention due to an inability to envision all of the members of the Marcouche group. In such a circumstance, you may reject the claim for indefiniteness under 112b. The materials set forth in the Marcouche group ordinarily must belong to a recognized physical or chemical class or to an art-recognized class, but there are times when it is sufficient if they clearly possess at least one property in common, which is mainly responsible for their function in the claimed relationship. When materials recited in a claim are so related as to constitute a proper Marcouche group, they may be recited in the conventional manner, or alternatively. For example, if wherein R is a material selected from the group consisting of A, B, C, and D is a proper limitation, then wherein R is A, B, C, or D is also considered proper. Claims using the term optionally require some analysis before concluding whether or not the language is indefinite. If the list of potential alternatives can vary and ambiguity arises, then it is proper to make a rejection under 112b and explain why there is confusion. Attempts to claim a process without setting forth any steps involved in the process generally raises an issue of indefiniteness under 112b. For example, a claim which read, "A process for using monoclonal antibodies of Claim 4 to isolate and purify human fibroblast interferon," was held to be indefinite because it merely recites a use without any active, positive steps delimiting how this use is actually practiced. You should also reject such a use claim under 35 U.S.C. Section 101 because it is not a proper process claim. Thus, the most appropriate course of action would be to reject the claim under alternative grounds based on both 101 and 112b. A trademark is a word, letter, symbol, or device adopted by one manufacturer or merchant and used to identify and distinguish his or her product from those of others. It is a proprietary word, letter, symbol, or device pointing distinctly to the product of one producer. A name used in trade is a non-proprietary name by which an article or product is known and called among traders or workers in the art, although it may not be so known by the public generally. Names used in trade do not point to the product of one producer, but they identify a single article or product irrespective of producer. A trademark or trade name is used to identify a source of goods, and not the goods themselves. You can use the Trademark Electronic Search System, TESS or TESS, which is available on the USPTO website, to determine whether a trademark identified in the patent application is a registered trademark or not. Proper use of trademarks requires that they be capitalized wherever they appear and be accompanied by the generic terminology. The relationship between a trademark and the product it identifies is sometimes indefinite, uncertain, and arbitrary. The formula or characteristics of the product may change from time to time, and yet it may continue to be sold under the same trademark. In patent specifications, every element or ingredient of the product should be set forth in positive, exact, intelligible language, so that there will be no uncertainty as to what is meant. Arbitrary trademarks, which are liable to mean different things at the pleasure of manufacturers, do not constitute such language. Thus, if a trademark or trade name is used in a claim as a limitation to describe a particular material or product, the claim does not comply with the requirements of 112b. However, the presence of a trademark or trade name in your claim is not, per se, improper under 112b. You should carefully analyze the claim to determine how the mark or name is used. Trade names are permissible in patent applications if one of two conditions is met at the time of filing of the complete application. Either their meanings are established by an accompanying definition which is sufficiently precise and definite to be made a part of a claim, or their meanings are well known and satisfactorily defined in the literature in this country. If the product to which the trademark refers is set forth in such language that its identity is clear, you are authorized to permit the use of the trademark. If proper identification of the product referred to only by trademark or trade name is deemed necessary under the principles set forth in MPEP 608.01(v), but is omitted from the specification, you should reject any claims based on the identification of the product merely by trade name or on the ground of insufficient disclosure. If the product cannot be otherwise defined, an amendment defining the process of its manufacture may be permitted. Such amendments must be supported by satisfactory showings establishing that the specific nature or process of manufacture of the product, as set forth in the amendment, was known at the time of filing of the application. For example, Coca-Cola is a trademark, but may be used in connection with beverages and syrups for the manufacture of such beverages. For example, carbonated soft drink. To conclude this discussion of 112b, you are reminded that since the claims define the scope of patent protection, it is of utmost importance that patents issue with definite claims that clearly and precisely inform persons skilled in the art of the boundaries of protected subject matter. Therefore, you must reject claims that do not meet this standard under 112b as indefinite. Such a rejection requires that the applicant respond by explaining why the language is definite or by amending the claim, thus making the record clear regarding the claim boundaries prior to issuance. Rejections under 112b must clearly identify the language that causes the claim to be indefinite and thoroughly explain the reasoning for the rejection. 35 U.S.C. 112b is a powerful tool for clarifying the boundaries of claims and enhancing the prosecution record. To review, here are some key points to remember about 112b. Ensuring that the boundaries of the claimed invention are clear to one of ordinary skill in the art enhances patent quality and clarity. Establishing a clear written prosecution record of how the claim boundaries were defined prior to issuance depends on both examiners and applicants, and clarifying the record establishes a foundation for claim interpretation throughout prosecution and the life of the patent, which benefits the examiner, the applicant, and the public. We will now discuss the requirements of 35 U.S.C. Section 112d. 112d states that a claim in dependent form must contain a reference to a preceding claim and specify a further limitation of the subject matter claimed. This means that a dependent claim is construed to contain all of the limitations of the claim to which it refers, plus the additional limitations that it must further recite. For example, Claim 1 is an independent claim and recites limitations A, B, C, and D. Claim 2 depends on Claim 1 and properly contains a reference to Claim 1. Claim 2 restates the structure of Claim 1 and further contains limitation E. This means that Claim 2 is construed to have limitations A, B, C, D, and E. A dependent claim is directed to a combination including everything recited in the base claim and what is recited in the dependent claim. It is this combination that must be compared with the prior art, exactly as if it were presented as one independent claim. When a dependent claim does not contain a reference to a previous claim and does not specify a further limitation of the subject matter claimed, it does not satisfy the requirements of 112d. You should reject it as not satisfying the requirements of 112d, but then examine it on its merits. An improper dependent claim includes but is not limited to 1. A claim that fails to specify a further limitation to the independent claim, or 2. A claim that omits an element from the independent claim. For example, if Claim 1 recites the combination of elements A, B, C, and D, a dependent claim reciting the structure of Claim 1 in which D was omitted or replaced by E would not be a proper dependent claim, even though it placed further limitations on the remaining elements or added other elements. This is an example of a dependent claim that does not meet the requirement of 112d because the dependent claim does not specify a further limitation of the subject matter claimed. The recitation of metal broadens the scope of Claim 1. In this example, Claim 2 is directed solely to an atorvastatin acid and depends from Claim 1, which included 1. Atorvastatin acid, or 2. Atorvastatin lactone, or 3. Pharmaceutically acceptable salts thereof. Thus Claim 2 further limits Claim 1 by excluding the lactone as well as the salts of the acid. The Pfizer court concluded Claim 6 depends from Claim 2 and claims a hemicalcium salt of the compound of Claim 2. That is, it seeks to reintroduce a salt into the scope of the claim. This is an example of a dependent claim, Claim 6, that attempts to broaden and not further limit the claim from which it depends, Claim 2. Due to this claiming structure, Claims 2 and 6 are now dealing with non-overlapping subject matter, and Claim 6 should depend directly from Claim 1 and not through Claim 2. When making a rejection under 112d, use form paragraphs 7.36 and 7.36.01. Be sure to include an explanation of why the claim does not further limit the base claim from which it depends. Applicant may respond to a rejection under 112d by writing the claim in independent form, making an appropriate amendment to the claim to correct the deficiencies, or showing that the dependent claim complies with the requirements. You should now be more familiar with 112B and 112D and how they are applied during patent examination.